Welcome to Employment Law This Week. I'm George Whipple. It's been almost 2 months since the Supreme Court issued their opinion in Dobbs versus Jackson Women's Health Organization, rescinding constitutional protections for abortion. In the wake of that decision, the federal government and the states have been introducing new legislation and issuing new guidance almost daily. Sarah Hall and Elena Quattrone from Epstein Becker Green's White Collar Practice Group are here to tell us how employers can navigate enforcement in this post-Roe v. Wade landscape.
The post-Roe legal landscape for employers is constantly changing on a day-to-day basis, and it has become a very complex environment.
Companies of all sizes in a variety of industry, not just limited to healthcare, can be subject to government investigations, especially any company that operates in a highly regulated industry. Healthcare, finance, publicly traded companies, for instance, are all fair game when it comes to government inquiry and potential enforcement, as are their employees and executives.
When it comes to some of the big decisions that employers are making these days, one of the issues that comes up is, should the company offer a travel benefit to its employees who live in what's referred to as a banned state, a state in which state law bans or restricts in a significant way abortion-related procedures. If that employee resides in a banned state and wishes to travel to a non-banned state or a state where abortion remains illegal, does the employer wish to cover the travel costs for that employee? That's a big issue that companies are grappling with. From the enforcement standpoint, if a company does decide to offer that type of benefit, companies need to be mindful of what documentation they're creating by offering this benefit that could potentially be used against their employee, against them as the company, if there were an enforcement action that was brought by the banned state.
The most obvious sign that your company is under investigation is that law enforcement executes a search warrant at your company. Less obvious, but similarly telling, is that law enforcement executes a search warrant at a home or other location connected to an employee, former employee, or business partner. Another warning sign that your company or an employee may be involved in investigation by the government is that your company or an employee within your company receives a target letter related to company business. A target letter is a letter from a prosecutor advising the recipient that he or she is the target of a grand jury investigation and generally describes the subject matter of the investigation.
If employers are in receipt of a subpoena or otherwise learn that the company or the employees are being investigated, the most important thing to do is to quickly retain qualified outside counsel who can advise on the complexities of that particular state's law, but also see the broader nationwide context of what is happening throughout the United States.
Thanks, Sarah and Elena, and thank you very much for watching. We'll see you next time.